retention, and future viewing of this meeting. This meeting is now being live streamed. Thank you.
Good morning. The hour of 8:30 having arrived, I would like to call the September 28th, 2021 meeting of the Securities Litigation Committee to order. May we have a roll call to establish a quorum, please?
Yes, you shall, sir. Mr. Gregory Jordan, Chair.
Here.
Senator Vincent Hughes.
Matt Lindsay on behalf of Senator Hughes.
Thank you, sir. And Representative Schimmel.
Yes, I'm here.
Thank you, sir. Quorum is established.
Thank you. I'd like to welcome Mr. Lindsay from Senator Vincent Hughes' office and Representative Schimmel to the meeting today, as well as all of the other board members, staff, and designees. The first order of business for today is the approval of the minutes of the February 24th, 2021 Securities Litigation Committee meeting. May I have a motion?
So moved.
Second?
Second.
Okay, the motion has been moved and seconded. All those in favor say aye.
Aye.
Aye. Noes? Hearing none, the motion is approved. Moving on to old business, we have a couple of presentations today. The first item on our agenda is an update on the establishment of the Securities Litigation Pool, which we are doing concurrently with PSERS, and I believe Mr. Jeffrey McCormick is going to give us a briefing there.
That's correct, Mr. Chair.
Please proceed.
Good morning, committee members. The update on the Securities Litigation Pool is that when the SERS and PSERS boards voted to be represented by a independent legal office, independent of the Office of General Counsel, OGC requested that we no longer use their securities litigation pool of pre-qualified outside litigation law firms and to establish our own pool or one joint pool. We decided to work together with our counterparts at PSERS and to establish a pool. We published a RFQ, which was a request for qualifications to get a pool of, again, pre-qualified firms that should SERS or PSERS ever need a securities litigation counsel for if they wanted to try to take an active role in a case by applying to be the lead plaintiff in a class action suit, or if they wanted to opt out of a class action litigation and bring its own independent claims. We might need counsel in order to do either of those things, to bring a claim in an international case. Then we would post an RFP for that particular case just within the pre-qualified pool of firms. So that's how the pool would work. We received, I believe, 21 proposals in the request for qualifications. There was an evaluation committee that was made up of lawyers in the legal offices of both SERS and PSERS, as well as I believe we had one executive office employee from SERS as well on that committee. And 17 of the 21 met the minimum qualifications to be in the pool. Committee members, you'll see on board docs under agenda item 4A in the executive content tab, you will see a list of the established, at this point in time, securities Litigation Pool of SIRS and PSIRS. There are 17 firms there. One of the two of the firms that didn't qualify asked for a debriefing meeting. There were members, again, of SIRS and PSIRS legal offices that held those meetings with those firms. And one of those firms has put forward a good case to perhaps be reconsidered. So this list is not necessarily final. They're still being reconsidered. We need to have another meeting to see if we would like to let that other firm in and have there be 18. But for now, these are the 17 firms that are in the pool that are established. And it was a little bit of a project to put it together, but we worked pretty well with the PSIRS folks, and we feel like we have a pretty deep bench now of qualified law firms that mostly from the East Coast, New York firms. There's some Philly firms. There's a Los Angeles firm, but it's a good deep bench of well-qualified and established outside securities litigation firms, so we feel comfortable and good about having established that. Does anybody have any questions about the pool at this point?
Okay, thank you, Jeff.
Okay.
Moving on, our next item of business here is a discussion of the amicus brief that we filed in support of the Arkansas Teachers Retirement System versus Goldman Sachs. As you may recall, in February, I believe we authorized the legal staff to proceed with this, and I believe Britt is going to lead the discussion on this.
Yes, sir.
Please proceed.
Thank you. The committee members and the board members will be able to find the legal memo that I wrote in under 4B, tab 4B in board docs. I will not dominate your time in getting hopefully in too much into the weeds this morning with you because I provided the memo. Of course, I'm happy to take any questions, but I certainly want to be judicious with my time and try to hit the high points for you this morning. So as Mr. Chair correctly said, this is regarding the matter of Goldman Sachs Group versus Arkansas Teacher Retirement System. This was a 2021 decision of the United States Supreme Court, and this was related to a securities fraud class action. It's important to note that SIRS was not a party to this litigation. Like Mr. Chairman said, it was a signatory on an amicus brief. To be an amicus curiae means to be a friend of the court. So, as I mentioned, while we're not a litigant in this matter, SIRS signed on to support the Arkansas Teachers Retirement System in their litigation with Goldman Sachs. In order to kind of frame this, these are pretty nuanced. I'm sure when you read the memo, you saw these were pretty nuanced issues we were dealing with. So in order to kind of frame this a little bit more, I'll give just a little bit of legal history. A lot of this case relates back to a Supreme Court case from 1988 called Basic v. Levinson. This case was a case where the Supreme Court articulated what's known as the fraud on the market theory. This theory gave rise to what's called a rebuttable presumption of reliance in securities fraud cases. I know that was a lot to unpack, and I will address those points that I just made after I kind of just briefly go through the conclusions of the court, and I'll delve deeper into what I just mentioned there. But first, I'll go into the holdings of this case. And so in this instant case, when the Supreme Court was analyzing the presumption that was set forth in Basic v. Levinson, it held that lower courts should consider whether the challenge statements that were so generic and non-specific that they didn't distort the price of a security in question. So basically, this court was saying it should consider the generic nature and the non-specific nature of statements as to whether the price of a security was distorted. I'll just remind the members of the board that if you're looking for any facts of this case, it's located within the memo. I'm kind of giving you the down and dirty rulings from this court, and also I can answer any questions after this. But so I'll just continue on with where I'm going here. So with this particular question about generalities, general statements, and whether they should be considered by a lower court, the Arkansas teachers argued at the Supreme Court level that the second court actually did correctly certify this class. But this argument did not prevail. The Arkansas teachers was basically saying that the lower court shouldn't have to consider generic statements at the time of class certification. So because of this, the instant court remanded this matter back down to the Second Circuit Court of Appeals to take in more information, so to determine whether the generic nature and non-specific nature, and whether or not that they had any kind of price impact of the security in question. So this actually was a win for Goldman Sachs. And keep in mind, we were supporting, of course, Arkansas teachers at this point, so we do not prevail on that point. Our friend, who was a litigant, Arkansas teachers do not prevail on that point. The second holding is that the court held that in order to rebut the presumption of reliance, which I'll go through here in a little bit, defendants, in this case Goldman Sachs, have the burden of proving that the challenge statements in fact did not affect the price of securities. And this actually was a win for Arkansas teachers. So I gave you the down and dirty holdings from the court here, and I'm just going to now go into unpack that a little bit more. So the fraud on the market theory, and this is what kind of arose from basically Levinson, that 1988 United States Supreme Court case. This theory is the idea that stock prices are a function of all material information about a company and its business, and it applies in open and developed securities markets where it can be assumed that all material information is available to any investor who's looking for it. And so essentially this theory states that under these conditions, there's a causal link between any misstatement and any stock purchaser, because the misstatements defraud not only the individual stock purchaser, but the entire market, and therefore affect the entire stock price. This fraud on the market theory creates a rebuttable presumption, which I mentioned earlier. This rebuttable presumption is an assumption made by the court that is taken to be true unless a party comes forward to kind of contest it and prove otherwise. So going back to this instant case, Arkansas teachers and Goldman Sachs, the Supreme Court found that the presumption of class-wide reliance that was established in their 1988 court case in basically Levinson requires, in this case, applying it to this case, that the defendant's statements be more than just generic guarantees. You may recall from reading this memo that Goldman Sachs made some generic statements on their website, such as, we put our clients in for skirts, etc. So this is a win for Goldman Sachs. I'll pause here and see if there are any questions on fraud on the market theory or rebuttable presumption or anything as well? Okay. Oh, go ahead, sir.
So, Britt, on the first question where the court sort of ruled in favor of Goldman Sachs, that has the impact of making it potentially more difficult to certify the class. Is that correct?
Yes, sir. So that could, and that's a reason why SIRS became a signatory on this amicus brief, is because the danger of this case creating a precedent that would make it more difficult for investor plaintiffs, similar to SIRS, to be able to aggregate claims based on this reliance, the standard of reliance that was set forth in the basically Levinson. And so, of course, from our perspective, we don't want it to become harder to have a class certified and to become and to aggregate our claims. We wanted it to remain sort of the same standard. But when you look at the holding of this case, it's pretty narrow in the sense where the court was considering generic statements, non-specific statements. So you are correct that it could, I'd say, create a concern that it would make it more difficult for plaintiff investors to aggregate claims as a class using that rebuttable presumption created in basically Levinson. But we'll wait and see. It's something that we'll kind of wait and see in how sort of like this evolves in the legal sphere.
Okay, thank you.
You're welcome. I'll move now to the court's analysis of the burdens of proof and persuasion. So the court essentially said that it was settled law that the basically Levinson presumption shifts the burden of production to the defendants, meaning that the defendants would lose if they couldn't present any evidence that undermines the alleged statement's presumed impact on price. This is kind of a mouthful. So even getting more narrow into the court's holding, the question to be answered here was after the defendants produced some evidence. The question became who then has the ultimate burden of persuading the court that the statements did or did not affect stock price. So in this instance case, the court held that the defendants not only have the burden to produce evidence to rebut the presumption from basically Levinson, but also on top of that, the defendants have the burden of persuasion to prove a lack of price. So this actually, on this point, was a win for Arkansas teachers. So I'll pause here to see if there are any questions on burdens of proof or persuasion. Seeing none, I will conclude by saying, as I mentioned before, the first holding of this case about a lower court being able to consider generic statements at the time of class certification, that matter, as you recall, was remanded down to the Second Circuit Court. And so what I will do, and of course Jeff and I will do, is monitor that and then see kind of how that plays out, and then we'll give this committee an update as to what the holding, kind of what arises from that since it was remanded down. But that's all I have at this point, sir, on my summary of this case. I'm happy to take any questions.
Okay, does anyone have any questions for Britt? Okay, thank you, Britt. It should be interesting to see what the Second Circuit Court has to say about this on remand. So thank you very much.
Thank you, sir.
Moving on with our agenda, we move up to the order of new business, and we have two items here today, a review of the class action receipts for the fourth quarter of 2020 and quarters 1 and 2 for 2021, and also our securities litigation report for 2021 quarters 1 and 2, and I believe Jeff is going to lead this discussion.
That's correct.
Please proceed.
Thank you. As Chair Jordan just explained, we have the class action receipts for the fourth quarter of last year, plus the first 2 quarters of 2021. They are located in agenda item 5A. As you can see, if you look at the fourth quarter report, we got just under $774,000 in the fourth quarter received by SIRS on proofs of claim in cases that have settled, and the proofs of claim were filed on SIRS' behalf by our custodial bank, Bank of New York Mellon. They handle all proofs of claim on SIRS' behalf on cases where we have losses and where we're not an active member, we're a passive member of the class. Usually these cases, once they get past the class certification stage, if they can, if they get past the motion to dismiss stage, they're into discovery. At some point, usually in that stage, the case will settle. The courts will send out a notice to all potential passive members of the plaintiff's class. And then in order to preserve your claim, you have to file your proof of claims with the court administrator. And as you see on that list, those are all cases where BNY Mellon has filed those proofs of claim on our behalf. The numbers that come in can vary. It can depend on, how many, if we had a large amount of damages and holdings in a particular case. The number can also fluctuate based on, how large the settlement pool is, and then how many folks file claims. So there can be a lot of factors as to why, if you look at some of these entries, some of them are one's $17.23. Another one a little earlier in the month is for $258,000. So it can vary greatly from matter to matter with those factors. If you look at the second report here of the receipts, you'll see in the first quarter we received another almost $700,000. And in the second quarter of 2021, another $271,000. So it's a steady stream. It is pennies on the dollar, but that's sort of how settlements in these types of cases work. But again, this is demonstrative of BNY Mellon, filing those proofs of claim on our behalf, and we've got a steady stream of settlement receipts coming in on these cases. If we move on to the securities litigation, any questions on the receipts, the class action receipts? All right, hearing none, we'll move on to agenda item 5B, which is the securities litigation reports for the first quarter and second quarter of 2021. Looking at the first report, you'll see that we have, these are listed class actions. We've listed by defendants. We will get notifications from various sources saying that there's a case that's been filed and we think that SIRS might have some a good amount of damages in this case. And so when we get those types of notices, we send them down to get a spreadsheet of data of SIRS holdings and buys and sell transactions during a particular class period, 2 sets of dates. And then we have our internal group go through and come up with a damages analysis. If it's close to the established thresholds that this committee has established, which is in the far upper right-hand corner of these reports, you see the $10 million lead plaintiff threshold, $7.5 million settlement opt-out threshold, and the $1 million for the international. Depending on the type of case that these are, we then get damages figures. As you can see, for instance, in the first quarter of 2021 report under February, for instance, if you look at the second entry, ExxonMobil, we did have a damages calculation of over $5 million. But again, that was to be a lead plaintiff in the case. Our threshold in order to seek, further information and do a deeper dive analysis on whether to file an application to be a lead plaintiff in a case is $10 million. And that's, again, because through experience and these law firms that we've worked with, usually the lead plaintiff is always the applicant that has the most damages. They figure that the litigant, the plaintiff with the most damages, will put in the most effort into the case on behalf of itself and the group, and do a good job on behalf of the class. But according to research and experience, usually the winning applicant has in the tens of millions of damages. So that's why we recently raised, I think our threshold had been $3 million, but every time we met or exceeded that and we would do more research, and they might say, yeah, you've got a good case here and, your damages are provable. However, 7 million or 10 million or even 15 million sometimes, we're seeing that there are going to be other applicants that have much larger sums of damage, and therefore, our chances of winning an application are slim. So that's why we raised the lead plaintiff threshold, and we have had cases that go over that number, and that's when it becomes a little bit more realistic that the court might grant an application to SIRS to be a lead plaintiff. So, again, this is just a summary of all the cases that come in and that we do, further research on. When we get our damages number, we usually double check it with the law firms, again, that are in the pool. This is their expertise. They will take on these cases where they're paying all litigation costs up front. So, it's their lifeblood. They are able to, what their final number is usually something that is very reliable, because they can't go in and, represent us on a contingency fee basis unless we've got a really strong case. So we always double check those numbers through those firms, and then again, we put them up against the thresholds, and in neither of the first or second quarters did we have a matter that met any of our thresholds. Does anybody have any questions about the report for either quarter? Okay, thank you.
Thank you, Jeff. Moving on, our next order of business is committee comments, concerns, or questions. Does anyone have any concerns or questions? Okay, hearing none. I'm sorry, go ahead.
I have none.
Thank you, Representative Schemmel. Hearing no questions or comments or concerns, our next order of business is the motion to adjourn. May we have a motion to adjourn?
So moved.
Second?
Second.
The motion to adjourn has been moved and seconded, and we are officially adjourned at 9:02 a.m. Thank you very much.